Jarvis.
Thank you, Judge. Good morning, everyone. I want to first address that what a beautiful new courthouse the citizens of Okaloosa have. It's absolutely fabulous. And it's got state-of-the-art technology. It's all over the place. Got TVs, got everything. It is fabulous. Now, me personally, you can tell by looking at possibly the salt in the beard, I'm a little technologically challenged, let's say. So, but that's not to say that we aren't going to have things and exhibits that we're going to show you up here. It's just you might not see my fingers touching it, but it'll be there. I expect also that you're going to see a lot of evidence and a lot of diagrams and graphs on these TVs. Some of them are going to magically appear behind me at some point in time. But I do want to reiterate, just like the state said, that what I say and what the state says is not evidence. The evidence is going to come from that witness stand. And if you don't hear it, if it's not presented or doesn't come out from there, then you're not to be concerned with it, just like the judge said as well. So, wow. That was a very interesting theory the state has proposed to you. It'd be very interesting to see if they'll actually be able to back that up. There's a blank canvas before you right now, a blank canvas to paint. And the state's going to attempt to start painting that canvas. And what type of picture you see or the clarity will depend upon what they put up there. I don't believe that the state is going to present evidence during this trial that's going to paint you a very clear picture of what may or may not have occurred. We know that Melissa Howard is dead. We know she died back on January 6, 2006. But how it happened, how it occurred, I don't believe the evidence is going to show how that happened and who did it. I think that's what the evidence is going to show you. There's 13 years of information that y'all are going to have to consume. And the evidence is going to show the state has some problems, and lots of them. And through the magic of technology, there are some of them that I want to address. Identity. You're going to hear from two DNA experts. One's from FDLE, Florida Department of Law Enforcement, and they're going to say, I anticipate that their witness is going to say that there is some DNA that matches Russell. I believe that's what she's going to say. However, on cross-examination of that witness, let's see how she arrives at those conclusions. Let's see how she formed that opinion. It's going to be very interesting. Were mistakes made? I think even through the state's opening, they admit that there was a contamination done by this very analyst. I think that testimony is going to be out there, that a contamination occurred during this investigation of this trial. And that mistakes were made. And it's going to come out through cross-examination. The contamination occurred on the most important piece of evidence in this trial. You're going to hear B20E. You're going to hear, and you're going to hear lots of it. Now, we are going to present Candy Zuleger. She's our expert. She has years of experience. She's a former FDLE lab analyst. Okay, she's worked at FDLE before, and until recently, she owned her own lab. She's testified and assisted in numerous cases around the country and even internationally. Candy Zuleger is going to explain that the DNA found on that was tested by the FDLE analyst could be touch DNA. And she's going to explain to you what that is. That when Russell was, as the state has already admitted, when Russell was at her house 2 days prior, that his DNA, touch DNA, could have been left there. He could have sat on the couch, and he could have left some DNA there, or any other ways could have been left there. And Melissa Howard could have sat down on the same couch, and I think the evidence is going to show that that's a possibility that could have occurred. She's also going to explain that the DNA is not a match of Russell. That's what our expert's going to say. It's not a match. So you're going to hear from two experts. One's going to claim it's a match. The other one's going to claim it's not a match. So it's not quite as clear and dried as the state would have you to believe. She's going to explain that Russell, and I stress, only could be a possible contributor. Only could be a possible contributor. That's very interesting that you need to listen to her testimony about. She is going to explain that there are a lot of other possible profiles, meaning people that could leave the same DNA and it not be Russell Holbrook. I ask, and I know that you will. Y'all have been very attentive in jury selection. One of the most attentive voir dires I ever attended. I know that you're going to listen carefully to what these witnesses say. Now, the next thing is motive. For 13 years, Crestview Police, Florida Department of Law Enforcement, investigators from the State Attorney's Office were all unable to produce a motive for Russell to commit this crime. 13 years. Couldn't produce one. No motive. Absolutely no motive. But yet, you may or may not hear from Miss Gina Baker from the state that she might have given a statement 30 days before this trial. 30 days before the trial. She might be given a statement. Something that she just had to talk about. Opportunity. The state briefly touched about that. Briefly touched about opportunity. Imagine, if you will, trying to collect your whereabouts from events that happened 13 years ago and piece together what you were doing for 1 hour on a day 13 years ago. How difficult that must be. As challenging as that is, to figure out what somebody was doing one night, 1 hour, 13 years ago, I believe that we're going to be able to do that. The state has already admitted that they believe there's going to be testimony that shows that Russell was at a birthday party, and there's going to be witnesses that he was there at the birthday party, including his daughter Danielle, his brother Michael, Michael's girlfriend Melissa Soule, and others were all at this birthday party. And at some time around 8:45, that he had to start rounding up people to go bring Danielle and Brian back to their house at Darlene Cooper's house. And that the instructions had been, and the state's even in their own opening, agreed that he was supposed to be roughly there around 9 o'clock. Now, the state has also stated that there's going to be a phone call that was made by Danielle. That was roughly around 9:24 that night. After she got dropped off, and shortly after being dropped off, she makes a phone call at 9:24 p.m. Shortly after that, there's going to be testimony that another phone call is made at 9:29 from Russell Holbrook to Gina Baker. And I'm not sure we're going to hear what the contents of that statement were, but a statement was made, a call was made at 9:29 to those two individuals for him to pick up some medicine. So Russell and his brother, who was riding with him, go to Walmart. Y'all are going to see a video of Walmart. It's going to have timelines on there of when these individuals went into Walmart and when they left. One video says they arrived at 9:35. One says they arrived at 9:37. What we do know is they left at 9:40. And shortly thereafter returned back home to the birthday party. Left, dropped kids off, went to Walmart, came back home, all wearing the same clothing. No one's frazzled. No one looks any different. No blood. There's nothing on these individuals that would indicate that Russell had been in any gruesome murder during that time frame, during this timeline. It's going to be very difficult, I believe. And I think the evidence will show it'll be very difficult to have done this so-called murder. Just didn't have the opportunity. There's problems. Not enough time. Just not enough time to have done that. It's just not there. And I think that you're going to hear from some of the birthday party individuals, one of which is Gina Baker, and she's going to admit to you that Russell didn't have enough time to do this. She said that more than once. Just did not have enough time to do it. Even she admits that. And I would ask that after the close of all this evidence that you're going to hear, and you're going to hear two sides to what happened that day, that you come back with a verdict and return a verdict of not guilty. Thank you very much.